So yeah, moving ahead. What are the obligations that we need to consider while considering a notice is what I have already walked you guys through. First thing was that it has to be very simple, specific. It has to be unambiguous. It cannot be a conditional consent. So let's say, for example, you visit a website, and I guess all of us have had this experiences that you want to read an article, and only the first paragraph of the article is accessible, and they ask for you to sign into the website. Once you sign in, only then you can read further about that article, or you can go through the website. So this is a conditional consent. This is not unconditional. It's not unambiguous, and this cannot be considered as a valid consent, because you're forcing them to sign in. You're forcing the user to give their PII, and only then you are going to provide them the service. So this is not like they don't have a choice. They cannot deny here. So this is something that is a bad practice, and we cannot do this further. So organizations or the websites who have such practices would have to change and implement a different process here. Then it cannot be a pre-ticked box. So so one quick question here, that as per your understanding, what do you think that Indian data privacy law, is it an opt-in mechanism or is it opt-out? I mean, it's very simple, but people do get confused here in these terminologies. So what do you guys think? Is it an opt-in or opt-out mechanism? About opt-in, opt-out mechanism. So yeah, we are thinking on the same line, that I just wanted to understand if you all know that what a opt-in, opt-out mechanism means. Opt-in mechanism is a clear affirmative action from the data principal that they want to give their permission for the processing of their personal data. It has to be clearly an explicit action from the end of the data principal. But opt-out mechanism is one example that I was talking about was a pre-tick checkbox. So wherein if the checkbox is already ticked, the user will only have a choice to maybe untick the box. Now this is something that the opt-out mechanism would be referred here. So India has an opt-in mechanism as per the data principle, the data privacy law, that you have to first collect the permission or the consent of the data principal, and only then the processing has to be done. So consent is the very strong lawful ground or the legal basis for processing personal data, and the other ground that we have under DPDP is the legitimate use. So most of the processing that is being done is as per consent. Now, one thing to note here is that does the consent management requirement have any effect on the processing that we've already begun in the past? So the example that I was talking about here was that, let's consider, for example, now most of the organizations have already collected the personal information and they are processing. So the consent, maybe it was verbal or it was written, the process was not in place. So now what do the organizations do? So for the processing that already started in the past, the only requirement is providing adequate notice about the processing that is being done. Notice has to be given within reasonable period, and there is no timeline given at the moment. So the processing that began in the past, for those processes, we would give adequate notices, and we would ensure that all the data principals are aware about the processing that we are doing. So we meet the requirement. Now, consent manager is something that I already walk you guys through. That would be a bridge between the data fiduciary and the data principal, who would manage, review, and withdraw her consent through a easily accessible format. And it could be a platform, it could be a third-party entity, it could be a person. So that would help the data principal to understand the processing, to maybe understand what the fiduciary is doing, and it would ease the process of giving the consent and withdrawing the same. This would be the role of the the consent manager. Now, another thing here is about the different rights of the data principals in picture. So, under DPDPA, there are 4 rights that have been enlisted. Right to access the information. The data principals can have access to the information about the processing that is being done, what kind of measures are we taking, everything about the processing of personal data. They have this access, right? Then they can also correct the information, they can modify, they can change the information. Let's say, for example, you had given your address or your phone number or your email ID, and now there is a change to that, there's a modification to that. So you can reach out to the data fiduciary and you can get it updated then and there. Then another right is right to grievance redressal. So if any of the data principals have any complaints or they have any queries or they have any issues apart from the rights that are enlisted, they can avail the right under here. That is the right to grievance redressal, and the data fiduciary has to have a officer in place. The grievance officer has to be there in place. And the last right, that is right to nominate. This is something very different, and this is something that we've not seen in GDPR. But let's say, for example, you have a nominee for your bank account. So similarly, there would be a person whom the data principal would nominate on their behalf to manage their consent and the processing of their personal data if there is a mishap or a disability or they are no more. So on their behalf, they would manage all the processing of the personal data. Now we are considering personal data as an asset here, and that's why we've increased the importance here that you can also nominate a person. Like the law has basically considered this perspective to give this right of nominating anyone on their behalf to the data principals. So that was all around consent that we had to discuss today. And there is a course that the SARO Academy has come up with, C-DPO. And as we all might know that under the new data privacy law in India, the DPO has to be based in India. So if you take up this course from SARO Academy, you would be a certified DPO, and you can skill up your career in data privacy. Or if you're starting your career in data privacy, this would give a hands-on to what all things you need to understand, the different concepts that are being covered from the Indian perspective. It would be very beneficial. Now, who all can opt for this course? So if there are any legal professionals, any HR managers, or there are compliance officers, or if we are maintaining any data, any managers who look after the processing of personal data and would have to comply with the requirements of the Indian data privacy law, then they can take up for this course. And the benefits of this course is basically, that's what I was talking about, is that it would enhance your career. It would give you more detailed understanding about what all other things you need to consider while you are complying with these data privacy requirements. And you would have a thorough walk through the entire process, the law, the requirements, the different terminologies, the processes, so that you can set it up for your organization. And it would be beneficial in a way to boost up your career. And these are the different functions that a privacy professional has to follow. So they need to perform data discovery, have to manage the PBDs, the PIAs. They also have to look after the data breach management, if there is a vendor risk assessment. These are the different activities that a privacy professional has to perform. And as part of the course, we would walk you through these activities in detail and the requirements. How can you comply with the other requirements as well? One more thing that we have at the academy is my team would share a link for the mentorship program that we are running. So if you are new to data privacy and you've just started your career here, you can also opt for a mentorship program. And there are mentors that we have at SARO Academy. You can have a one-on-one with the industry experts and get a career insight as to how can you start your career, how can you skill up, what all things you require to learn and understand. So do join our mentorship program. My team would share a link for the mentorship program in our chat. And yes, that is it. The forum is open. If in case you all have any questions around the consent management requirements of the framework, then we can discuss here. We are also expecting that we would get detailed guidelines or rules around how to set up the notice, how to set up the entire consent management framework, what all things have to be included in the notice, how can we set up the consent withdrawal mechanism, and how do we notify for the processing that has been started in the past. So these things are something that we are looking for more clarity. Okay, so we have a question here that what is the difference between consent manager and data protection officer, and what are their powers under the Act? Okay, so Now the DPO is something that is who is accountable to the data fiduciary. So the company will have a designated position or a person who would act as the DPO and who would look after the data privacy compliance requirement and oversee everything across the organization. Now the consent manager is not someone that the fiduciary or the organization has to appoint. This is someone who the data principal will choose for themselves. It could be a tool, it could be a third party, but they are not accountable to the organization. So organization need not appoint a consent manager. The consent manager is totally answerable to the data principal or the user, the individual who's sharing the personal information. Operate or what would be the roles and responsibilities, something we are looking forward to. But one thing that we know that the consent manager has to be registered with the board. So the data protection board will have a process in place that how can the consent manager register themselves. So at the moment, the basics, just to summarize the entire session, the basic requirements would cover that. First thing is have a notice in place, have a statement maybe displayed on the website that I'm doing these things on the like the processing of the personal data is being done in this way. The second thing could be setting up the withdrawal mechanism, setting up a mechanism in place for collecting consent on behalf of the minors, the person with disability, and also maintaining a record, a detailed record of all the consent processes being done. So when did the consent get collected, who gave the consent, what time, for what processes. And the part which is going to be difficult would be maybe displaying the notice in 22 different languages. So maybe consider hiring a translator or onboarding a technical tool in place so that the consent notice is simple and easy in all the languages. It should not change the crux of it. So yeah, and one more thing is that DPDPA has completely excluded the personally available information. So in case of GDPR, ideally we had to provide a notice, but in case of DPDP, the publicly available information is not to be considered in picture. So you need not provide notice there for the data principals to know about any of the processes being done because it's already available in the public domain. If there are any questions, please feel free to reach out to me on my LinkedIn profile and feel free to put a hi. Maybe we can discuss more around consent or how can you implement the privacy program in your organization considering the new act has been passed. See you all around. Thank you so much for joining. Thanks a lot. Bye-bye.